today. And my name's Karen Penfold and I'm the Human Resources Manager for Code. Quite a few of you may have spoken to me before on the phone or met me at the seminars that you've been to. So we're going to be going through today disciplinaries and grievances. Some of the aims and objectives of the session today. We're going to look at the aim to help practices increase their understanding of managing the disciplinary and grievance process and to comply with legislation and avoid making common mistakes. The objectives of the session today is to discuss an overview of employee rights relating to a fair dismissal process and to highlight the risks of not conducting a full and fair investigation, and also to explore how the iComply system provides useful policies and template letters that can help practices comply with their legal obligations. Okay, so quite a lot to get through there. Let me just click on the slide. I seem to have a slight problem on the slide notes. Bear with me a moment. So you can all hear me. I'm just trying to adjust the slides to, for some reason it's stuck at the moment. There we go. So learning outcomes for the session is to avoid potentially costly mistakes when handling disciplinary and grievance issues and to improve understanding of the ACAS Code of Practice relating to disciplinary and grievance procedures and how that relates, and to understand statutory employment rights relating to the disciplinary and grievance process. So a little bit of a mouthful, I'm afraid there. So again, I've had to condense this. We've only got sort of 45 minutes to get through what is quite meaty subjects really. And either grievances and disciplinaries could all be a subject on their own just to go through. So it really is to give you a taste and overview of how to deal with them and the key things to look out for. So overview of disciplinary and grievance procedures we're going to focus on. We'll break down the disciplinary process and what's involved. Also touch on the ACAS Code of Practice and its relevance to both of these procedures and the importance of being aware of it. We'll look at handling a grievance, we'll look at that later, and also touch on some useful policies and templates that we have on iComply, along with hopefully taking away some actions from today's webinar as well, back with you. Okay, so let's start with disciplinary and grievance procedures. So if on the members helpline, the first thing when I receive a call from members that are in this situation, potentially facing a disciplinary or grievance issue, is to refer them to, I always say, go and have a look at your procedures first, check your internal procedures. Those of you on iComply, we've got the disciplinary and grievance procedures in place. It's always a good idea to go and familiarise yourselves with the process. And that procedure, I mean, the idea of a procedure is to make sure that it provides you with a framework, not just it's a management tool of how to handle this situation. It will also lay out to team members and staff members what the expectations are, and what the repercussions are if they don't adhere to this code of conduct. And also you've got the legal compliance with that procedure, and it should also incorporate the guidance of the ACAS Code of Practice. So those procedures need to be communicated to all staff so everybody knows where they stand, and that's the key part of making sure when you start with induction that these key procedures are issued to staff at that stage. Now the ACAS Code of Practice, now this isn't a legal document as so people get confused with. It's essentially a guidance document, and it's a set of principles that is what we're meant to work, employers are meant to work to make sure there's a fair dismissal process and a fair grievance handling process. So I recommend that you download, this is on iComply as well if it's not on ACAS website, download the document, have a read of it. It's only about 10 pages long, and it will just give you an indication and familiarise yourself with what you should do in this situation. And really, we want to get to the point where prevention is better than cure. Nobody wants a culture of having lots of disciplinaries or grievances going on in their business. The problem is dealing with a disciplinary is very time consuming, it's very costly. There's also a high level of risk involved if you get it wrong, and it's not great for staff morale. You don't want disciplinaries to be something that's a tool to beat people with, a stick to beat them with. It should be there to correct behaviour rather than a form of punishment. And also you'll know grievances, once you start receiving grievances, if you don't deal with them, they sort of breed even more grievances on top of that. So try and communicate and nip things in the bud before you get to this stage, and it's all about that communication. Okay, so if though, you're in a situation where you haven't been able to, and sometimes it's out of your hands when it comes to this, and you're having to implement a formal procedure. So with the disciplinary, we're going to focus on disciplinaries first and then touch on grievances later. So if you're in this situation, now a disciplinary should be used really for two main areas, and that's for conduct issues, and we're going to break that down into misconduct and gross misconduct areas. And capability is the other issue, and this is normally dealt with because it's dealing with performance, correcting performance, and this tends to be dealt with under a separate policy. Capability we're not covering today, but it is in there. We have an iComply policy on that if you want to familiarise yourself with that. And that will cover correcting performance, improving performance issues, but capability can also be used for dealing with employees that perhaps are on long-term sickness and are not well enough to actually perform their job. So that's when you'd be using that. So if we think about examples of conduct issues, now misconduct, I'd say the majority, the most common ones that we're called the members helpline that result in perhaps formal action tends to be related to short-term absence issues. Persistent lateness is a common one when they've had lots of conversations, but it's got to the point where it hasn't improved. They're now calling in to say, look, we need to take some formal action. Other areas, and particularly in the side of compliance that we deal with, is when team members aren't following policies and procedures and compliance. And misconduct, it can be attitude as well, it can be insubordination, not taking instructions particularly well, and it can be, generally effectively if you hit that trigger point if they're on sickness a lot and short-term sickness, and you have a reasonable belief that it's maybe not genuine. So there's some of the common ones of misconduct. Now gross misconduct, you're moving into the more serious area. Gross misconduct is essentially where the employee has committed an act so bad that it has destroyed the relationship between the employer and the employee, and it's so serious that that can't be continued. So gross misconduct can be related to theft, fraud. We've had a few cases of that recently, and also violent or racist acts in the employer. If they act like that, then you'd be looking at potentially gross misconduct, and that essentially means an instant dismissal situation or summary dismissal, those of you might be familiar with, which is effectively a dismissal without having to pay notice. However, you still need to go through a process before you get to that stage and actually into a dismissal situation. Okay. So let's break down that disciplinary process, and essentially this is what your procedures should reflect, and it's also in line with the ACAS Code of Practice and what it mirrors here. So if you're in a situation where you have an employee that you have a reasonable belief or reasonable suspicion that they have done something wrong, and it could be a misconduct issue, or it could be a gross misconduct. So you start off with the allegation, the suspicion there, and it could be for essentially if you've got somebody who's under suspicion of perhaps stealing it could be from petty cash or theft in some way, and you've got reasonable belief there that has happened. So the next step would be to carry out a full investigation, and this is so essential. We're going to go into the investigation stage in a moment. A lot of employers at tribunal, this is where they fall down if they haven't completed an investigation. And then your next step is your invitation to the hearing, the formal action, and then it's the hearing itself, and then you've got the outcome, the decision after the hearing, and that can be made, we're going to go into that into more detail, that can be made at the end, or you can write to them as well with the outcome. And the next most important stage is the appeal stage as well, and this is another area where employers forget to offer the right to appeal, and they can fall down at tribunal in this area as well. What I will say, and I know this is a real problem for smaller employers, is that each of these stages should really be carried out by somebody allocated to somebody different rather than the same person doing them all. Now recently I had a situation where the actual employer was involved in an incident with their employee. There was an altercation and the employee left. Now the employer the actual manager involved then carried out the investigation. They also wrote the invitation to the hearing. They also stated they would be chairing the hearing and deciding the outcome and holding appeal. So automatically, whether the employee had committed the act or not, that would be deemed as an unfair dismissal process, an unfair process. So when you can, particularly if you're in a situation where you could be dismissing an employee, this is where you need to consider having somebody, say practice managers, to carry out a full investigation, and then allowing the principal to chair the hearing with a note taker present. And then if you can keep somebody back for the appeal stage, or you may need to consider an external resource if you're dealing with it in that situation, so to make sure that the process is fair. Okay. So suspension. Now people do get confused or get in a bit of a mess about when to suspend somebody or not to suspend someone. Now, if you have an employee that is on a misconduct and you're doing an investigation, for example, perhaps it's an employee that has been persistently late over the last few months, and despite informal conversations with the employee, this hasn't improved. So you would still do an investigation, in the sense you would collate all that information together, the amount of times they've been late, the amount of times you've spoken to them, and the lack of improvement. But this wouldn't warrant suspending the employee while you're deciding on the investigation or disciplinary action. However, if you have an employee who is perhaps being investigated for theft or fraud from the practice, and it could be facing an actual dismissal, a gross misconduct situation, then that's when you would actually think it'd be better for the business if you also think that this person could cause more damage or interfere with potential evidence that you're trying to collate, then suspension would be appropriate. Now, when you suspend, it's really important that it's not used as a form of punishment, and it's not saying that they are guilty of the alleged act. It's saying there's a reasonable belief that they have been involved in this. So take them to one side. If you can, do it privately, and also withhold, particularly if they're professional people, and if there is no foundation to the allegations and they're coming back and being reinstated, you don't want to expose yourselves to them raising a grievance about how they were treated in this process. So you would suspend and advise them of the suspension, that it needs to be confirmed in writing to them, and it should state that it's on full pay and it's pending investigation. The other key part of the confirmation should also state approximately how long you anticipate they're going to be suspended for, and that will relate to how long it's going to take you to do an investigation process. Now, in some cases where you're having to collate a lot of evidence or a lot of witness statements, that could take a couple of weeks, or whether you're waiting on, perhaps it's something from your alarm company or CCTV images. Now, but give them an indication, and also in the letter advise them that they need to make sure they're made able to stay in contact with you if you need to speak to them at all and get their statement. Okay. So then we move on. So you've had to suspend the employee. If we focus on if it's a gross misconduct situation, the full investigation is even more important and essential that you complete this. Now, an investigation is all about establishing the facts, and what you're looking to do is actually look to find the facts that both support the alleged act or the belief that you think this person has done, but are you also looking for evidence that may dispute it at all, that actually that it isn't there. And that investigation should be carried out by someone who can be neutral to that, and look at it as an overview. So you would normally give somebody, an investigating officer, this role. On iComply, we have an investigation record template. So it's so important to prepare your investigation. Who do you need to speak to? Which witnesses do you need to approach? And those witnesses, you need to ask them to prepare their statement, issue a statement, and also sign and date that statement. So you'd have that as evidence. It's also, you'd be, complete a complete record on here of everything you need to do and who you need to speak to. If you're speaking to the person who is under investigation, then at this stage they don't have a right to be accompanied. There's no statutory right to be accompanied to an investigation interview. However, if they ask to bring somebody in, if it's particularly emotive, it's a good idea to consider that. So that's fine for them to do that. When you're asking them questions to explain the alleged act, for example, if it's around the fraud, if you suspect them of stealing in some way, ask open-ended questions. Don't go in with accusing them. It's ask them to explain a situation of how things look, and give them an opportunity to do that. They may prefer just to give you a statement and then ask them to sign and date that, and that would then be submitted and used during the disciplinary hearing itself. So that's what the investigation stage is about. You're collecting information, facts, evidence, statements, bringing it all together to be able to what you're going to refer to in the disciplinary. But it's also, you may find during the investigation that it turns out there isn't any foundation to the allegation itself, and decide not to take formal action. So it is also there to help you decide which route you're going to take. Okay. Okay, so the disciplinary hearing itself, this is so important to get this right at this stage. There isn't any statutory amount of legal time that you need to give an employee to give them notice of when a hearing should take place. However, you do need to refer back to your disciplinary procedure and go by what it states in there. So if it's 24, 48 hours, make sure you adhere to that. If the sort of rule of thumb, if the employee is actually looking to face a gross misconduct or dismissal, then the more notice you should give them to prepare, the better. That's more reasonable. So what tribunals will be looking for is that has the employer acted fair, consistent and reasonable in how they have dealt with this situation. So we've got template letters on iComply that cover the invitation itself to disciplinary hearing, but what it should include is everything that you're going to be referring to in that hearing. So every piece of evidence that you have collated in your investigation, you should provide them with a copy of that beforehand. And really, if they produce anything new in the hearing, that's when you would adjourn to have a look and review that. But to make it fair, they need to see everything that you have around the allegation. So make sure that it confirms in the letter the time, the place. It's a good idea if it's somebody facing a gross misconduct situation to perhaps consider having it away from the practice as well, somewhere private and away from there. So the actual conducting of a disciplinary hearing, you should have the chairman, the person who's going to be chairing the hearing, who hopefully hasn't been involved in the investigation stage. And also you'd have a note taker present as well. And they wouldn't participate in the hearing, just but keep a good record of notes. Now, potential outcomes, depending again on which procedure you have. If you're not using iComply, maybe have older procedures. You'll see that there used to be the verbal warning stage, or the first written warning, and then it'll be final or second written warning, and then resulting in ultimately dismissal from that point onwards, or straight to gross misconduct dismissal in some situations. Now, the verbal warning stage is no longer recognised under ACAS, so it's not actually in our procedures anymore. But what I do advise is, if you're not going to take, not everything needs to be formal action, but you need, sometimes it's serious enough to warrant at least a warning to say, next time, then this will go, we're going to investigate and it will go further. So it's a good idea to perhaps put a note, what we call now as a note on their file. So for example, somebody who has been persistently late, that you've warned them to say, look, this is not acceptable, and now making it by having an informal meeting with you, but we're going to write this up and it's going to be on your record, and any further instances will result in a disciplinary action and formal hearing. So if with gross misconduct situations, it doesn't always have to be a dismissal situation. You can have other alternatives to dismissal, which can be demotion, or if you have multiple practices, it may be that you decide to move them, relocate them to a different practice. And so really dismissal should be an absolute last resort, but sometimes it can be so serious that you have no option other than to go through with that and terminate the employee's contract. If you are in that situation, you must write to them and with a statement of the reasons for dismissal. And this actually, at the moment, this only really applies to people employees who have had a year's worth of service with you, or anyone who has been dismissed relating to potentially one of the protected characteristics, say during maternity leave, or anything related to that, then you should always provide them a written reason. I think the safest bet, whether it's length of service or not, would be to still just provide them with a written statement, no matter what their length of service is, confirming the reasons for the dismissal, and most importantly, that you actually state on there that they have the right of appeal, which should state who they write to, outlining what is their appeal about, on what grounds. And it needs to be a reason, not just because they don't agree with the outcome. It needs to say why they didn't agree with it and what they want to be reconsidered. So it's a really important stage that the employers mustn't forget to do, because it can result in it being automatically unfair process. Okay. So going back to, I wanted to do this on a separate slide because members quite often ask me about the right to be accompanied and who they need to allow for this situation. Now, it states in the statutory right to be accompanied relates to a work colleague or a trade union representative. And this, when you read the ACAS Code as well, it's very clear that these are the two acceptable choices of people that you're able to bring as your companion. However, some people may ask for somebody different, or it's not appropriate for them to bring a work colleague if they feel that the topic itself is too emotive. And I strongly recommend that when an employee asks you if they can bring somebody outside of these two categories, that you really do consider those options. If it's, and it could be a reason they may need somebody with them if they have a disability and they need some support. If they have trouble with English, for example, they need support or an interpreter, then to make sure that you're not falling down by making the process unfair, you need to make sure you consider and provide that for them. So it's all about making it as safe for them as possible, that in the actual hearing that they have been given a fair opportunity and understand everything that's going on. Now, the role of the companion in the disciplinary hearings, now effectively they can fully participate in the whole meeting, the whole hearing. The only thing, so they can ask questions, they can put their side across, their view across. The only thing they can't do is actually answer on behalf of the employee that's under suspicion at that time. So they can't answer or speak for them. But other than that, they can fully participate and take notes and be involved in that way. So if you're in a situation, so you've had to dismiss somebody and it was for gross misconduct, and you've decided that the dismissal is, with instant dismissal, so therefore it's pay in lieu of there's no notice at all. So, and that you can only do that if it states in your contract that you're able to do that. So the timescale, so if they leave, they've got effectively 3 months from their last day of employment with you. And if there is notice involved, then it would be the last day of when that notice period ended. And effectively they have 3 months to make a claim, a tribunal claim against the employer if they feel they've been treated unfairly in some way. Now, unfair dismissal claims, and quite a few of you I've had conversations with that are familiar with this, that for an employee to qualify at tribunal and actually be able to make an unfair dismissal or constructive dismissal claim, they need to have at least 2 years of service with the employer to qualify for this. However, I always be really, really careful in this situation because it doesn't mean that employees who don't have 2 years with you, it doesn't mean that they don't have any protection at all or not able to make a claim. There is an absolute raft of legislation that still protects them. In particular, under the Equality Act, if anyone is dismissed and they're able to relate it to one of the protected characteristics, if they state that they have been dismissed because they are pregnant, for example, then they would be able to automatically log a claim, and actually the compensation for those types of claims is even higher than the unfair dismissal. So you still need to always follow a fair dismissal process. It's also, there's wrongful dismissal, there's fixed term contracts, so it's not to scare you, but there is protection there, whatever the length of service, even if someone's been with you for a few weeks. So once they've logged an unfair dismissal, or once they've logged a claim at tribunal, the next process is now, which has been introduced, is called ACAS early conciliation. Now, essentially, the employee, that they have to do this for it to be able to progress to a tribunal. This is the first step. They have to go online and log an early conciliation stage. Now, this essentially means that ACAS will get in touch with yourselves as the employer and will be the person of contact between yourselves and the ex-employee to try and agree a settlement and arrangement to prevent it from then escalating to the tribunal stage. And this was brought in on top of tribunal fees to essentially stop the amount of claims that were going to tribunal that really didn't need to. But this stage, all it will do, it's a month that you've got from going backwards and forwards. It will buy that extra month, and then the employee has another 3 months on top of that to be able to make a claim. Now, in this period, ACAS, they won't actually make a call on whether they feel the employee has a case or whether the employer doesn't. They literally sit on the fence and make no comment on that. So it's just literally just as a go-between. When we talk about the 5 fair reasons for dismissal, The only time that you can actually go through this fair process and dismiss anyone, and when you write in the statement of the reasons for dismissal, it has to relate to one of these areas. So this would come under conduct, which we talked about, misconduct, gross misconduct is in that. Capability is also considered a fair reason if you go through the process. Redundancy, and also if there is a statutory, if you break a statutory rule, for example, if you're a driver for a company and part of your role is you must be able to drive, if you were to lose your licence through the courts, then the employer would be able to go through this process and dismiss you because of that. And the other one that most people probably have never heard of before, the other fair reason, which is called some other substantial reason. So which pretty much covers anything else under that umbrella. And it's a very woolly reason, but it can be where, quite often it can be where a relationship has broken down and neither party has actually done anything wrong, but they just can't work together anymore. And it may be where there's been, a romantic relationship between a manager and employee, for example. They can no longer work together, so the dismissal would come under that some other substantial reason, as an example. So be careful if you are ever having to use that one. So that's we've gone through the disciplinary side, which is, there's a lot into that as well. And I'm sure you'll have lots of questions. But quite often when you're dealing with a disciplinary, grievance can come out of that as well. And you might be in a situation where you're having to deal with a disciplinary and a grievance at the same time. If it's the employee who's under investigation who's raised the grievance, it's a really good idea to cover off and deal with the grievance first before you progress onto the disciplinary side. So actually just defining the grievance, what is it exactly? It's not about an employee just being able to moan about something they don't like about their job. It has to be something concrete that they are complaining about. So it's a formal complaint about unfair treatment, that the employee feels they're being treated unfairly by the employer. Common examples, and I think the most common ones that we receive on the helpline for members over grievances that have been raised is where changes to their terms and conditions, their contracts have been made without any consultation, and it's been put on them to say this is what's happening. And that can cause no end of problems if that one comes up and you haven't gone through the consultation process. Another one that's quite common is the bullying allegations. I've seen quite a few from members where the dental team might have a nurse, for example, who feels that she's got been bullied by one of the self-employed associates, for example, and has raised that time and time again informally to the employer, but no action has been taken, so it's now become a formal grievance. If an employee actually puts in writing to you that they are unhappy about something in their treatment, even if they don't mention the word grievance, you need to treat it as that and take it seriously. Even if they don't state the word grievance, but they've got a concrete evidence that they're unhappy and feel they've been treated unfairly, you need to really acknowledge that and treat it in the same way. It can also come from a third party. We had a situation where a patient would regularly being inappropriate with a receptionist, for example, and this was ongoing for some time. The receptionist was feeling quite intimidated by the patient, raising it to the principal on numerous occasions over a 6-month period, and there was no action being taken to resolve this. That resulted in a formal grievance being raised and having to go through that process with them. So it's thinking about there's different types. It can even be as simple as a procedure not being in place, a health and safety breach where they feel that they're not being taken seriously and they feel their safety is at risk, and the employer really needs to acknowledge that. So again, going back to wanting to prevent these types of grievances being raised, and same with disciplinaries, dealing with a grievance is not only incredibly emotional and draining for the employee, it's the same for an employer as well. And it's a lot of work that's involved in going through the process with them, a lot of timescales that you need to meet. And it can, it's not great for motivation either. So you want to try and, as much as you possibly can, encourage communication, listen to your employees if they are telling you things aren't right. Get to the stage where you're having regular one-to-ones with them, regular meetings, and that open sort of management style. Because quite often one grievance comes through and you'll notice a sort of pattern of them will start happening from there. Okay, so the actual grievance process in itself, and going back to the ACAS Code of Practice as well, and our grievance procedures which mirror that. I mentioned a moment ago, it needs to be a formal complaint made in writing. about unfair treatment that the employee feels they're experiencing by the employer, or actions that the employer isn't taking. So once you receive that, it's really important that you go back to your procedure and you look at what the timescales are. Grievances should be dealt with promptly and within line with your procedures, and then shouldn't be left to fester, as that can result in something even bigger. And the worst case scenario, the employee ending up leaving or claiming constructive dismissal if they have the 2 years of service. So the next step, so complaint in writing, the next step would be to investigate. So in the same way you would with the disciplinary, you may need to investigate depending on what the grievance is about. If it's a complaint about procedure not being followed in terms of changing their terms and conditions, you would go back to speak to investigate who started that process, what records have you got on file, any statements from there, and collate that together. And we have the records that you would be able to use, the grievance and disciplinary records, that you can record all this information. So record everything, again, is really important. The actual meeting, so you arrange a meeting, ask them to come, and again, they have the statutory right to be accompanied by a trade union or a work colleague for this. Now, during the grievance hearing, it's all about letting the employee talk about what's happened, provide timelines, refer to their grievance itself, and it's not an opportunity to moan, it's about actually looking for a solution and an action plan. And it may be that mediation's needed, or it could be that more training's needed, and an awareness if an employee is making appropriate comments, for example. And so you would confirm what's been agreed in writing to them, and put that, send that to them, but make sure as well that they have the right to appeal. So that's another critical part of this process. Very similar to disciplinary, that's a key stage that people forget to offer. Because if the risk is, if employers ignore grievances, it can become even bigger. But the first thing that ACAS will say, or tribunals will say, is, were you given the right to raise a grievance, and was it dealt with? If you don't deal with it, or if you ignore it, and the employee has left because of it, a breach in their contract, then that would go in a tribunal. They would really frown at that, and that could be further compensation, or it would go against you, most definitely. So please, and for a happy environment, not just to prevent tribunals, is to deal with that and improve staff engagement. Okay. So I'm conscious of the time, so I'm trying to get through now because it is a bit of a meaty subject. Now, on those of you on iComply, we have so many documents, and I couldn't actually fit them all in onto this slide. So many documents that can help you to deal with disciplinaries and grievances, and templates. Now, overall, we have over 105 HR templates and documents to deal with any HR issue. But these in particular, if you familiarise yourselves with these as well, if you're in the middle of a grievance or disciplinary at the moment, certainly go back and make sure and see if any of these can help you as a tool. Now, coming on from that, to have a read of those, we were found recently by popular demand from our members that they use the HR support that they have with iComply at the moment, but we've been getting feedback that they want even more, which is great that that it's been so popular, and it's been really recognised. It's something that practices need to have if they haven't got a HR department, for example. So we are actually launching a comprehensive a more comprehensive HR service soon, which more details will be coming out. And this can either be a bolt-on to existing if you're an iComply member, or it can be a standalone package as well, which we're offering. So the total, I'll just talk through some of the benefits if you are looking at having the total HR and employment law package. It will provide you with the full HR documentation and also contract set up at your practice, which is something that a lot of members ask for and want sort of help with. There's annual contracts and HR document audits as well to make sure that your files, your employee files are up to date, that any amendments to contracts have been made. And unlimited access to a Code HR advisor and this is an important, with editing support. So we find we can review documents, and that's something at the moment to actually edit or make a document to work for your current situation. This will be something we'll be looking to offer. There's also an introduction of a web and phone application, which will help you manage your staff in terms of sickness and absence issue reporting. All of your staff correspondence and documents will be held on there, appraisals, reviews, everything that you want to keep together. And also that will have access, an employee can manage their own parts on that section as well. This is something also by popular demand. There will be the option to take out your own employment protection cover, and that will also cover you if you're in an event, obviously you've handled everything correctly, but if you're in the event where you're having to deal with a dispute or a tribunal stage, this cover will protect you for that. So pricing starts at $125 plus VAT per month for up to 10 team members. And we have got other packages for those that are non-members as well. If you'd like to know more information, I know we are doing some discounts and offers if you sign up before the 1st of September as well. So give us a call on 01409 254 354 to find out a bit more about that. So that's a HR package. So this is the part that I wanted to take away with you to think about today as well, is actions to take away and think with disciplinary and grievances. So review your current disciplinary and grievance procedures and ensure all your staff that have signed copies in their files as well. So this is under the induction when new team members come in, it is on the checklist, but just make sure those team members that have been with you a long time, that they have a copy and they're aware of it and know what the standards and expectations are. Managers who may have to deal with disciplinaries, familiarise yourselves with the ACAS Code of Practice. Download it, read it, make sure you feel comfortable with of the guidelines there and the principles around that. Because at the very least, if you follow that, it will reduce any claim from happening. Those people that haven't followed an ACAS Code of Practice, being aware it's an extra 25% on a penalty at tribunal they can put on as compensation. Keep good written records at all times. Even if you're looking to dismiss someone during probationary periods, make sure that you keep records during that process of conversations you've had, performance concerns, it's all on there. Where possible, do not have the same person deal with each stage of the disciplinary process. I mentioned that before, where you can consider external support. Encourage staff to raise and resolve day-to-day issues informally, wherever possible, have that open management style. And do take seriously all grievances being raised. However, they might seem small to you, but they could be big to an employee and they could escalate if you don't acknowledge them. Also, apply any actions or learning points for the future arising from a grievance, so your action to resolve it. Otherwise, it could end up in a bigger one. So I don't want to leave you with complete doom and gloom, but if you don't follow, it's just really reiterating the importance of following a fair dismissal process. The maximum award at the moment for compensation for unfair dismissal claims is $80,000 plus, and that's not including all the extras if you miss key stages of the process as well. So I know it's a bit of a meaty subject, so we are just going to move over to some questions now as well.